Hi, I'm Adele from the Groupwork team at Dundee Carers Centre, and I'm with Lorna Christine and Robin Beattie from local Solicitors Thorntons today. Thank you both for taking the time today to create a video explaining power of attorney and guardianship with us. The background to this video is that carers told us at the Groupwork programmes that they either didn't know enough about the topics or they were unclear about them, and they wanted to know more about both power of attorney and guardianship and to have any questions answered. So we organised online sessions, and you both kindly came along as guest speakers to share that information with the carers. The online sessions were really well received, but unfortunately some carers couldn't attend, possibly through work, other commitments, and they asked the Groupwork team if they could create a video that would provide them that information about power of attorney and guardianship, which they could watch at their own convenience. And that's where we are today. We're ready to do this video. If anyone's curious about the Groupwork programme, you could find information on the Dundee Carers website or call the centre on 01382 200 422. Now I'd like to pass over to Lorna, who's going to explain a bit about power of attorney. Thank you.
Thanks, Adele. So my name's Lorna Christine. I'm a partner in the private client team in Thorntons in Dundee, and I've specialised in this type of work for about 20 years now, which sounds a long time when I say it. And today I'm really going to give you a whistle-stop tour through power of attorney, just some of the main questions you might have. Hopefully we can answer any queries that you've got, and just give you some more information today. So just to explain initially, power of attorney is a document that we prepare. So it's a document that we prepare where you give power to someone else to act on your behalf if you're no longer able to. And it's a document that we draw up which contains quite a number of powers. In Scotland, attorneys can only act based on the powers in the deed. So we have to try and cover everything that might come up. So if you're ever putting a power of attorney in place, you might think it looks pretty complex, pretty lengthy. But the main thing to remember is that your attorneys always have to act in your best interest. So the key thing is really choosing your attorneys and picking people that you trust to act on your behalf. Now, we always recommend that you have at least 2 attorneys. And the reason for that is just in case something should happen to your first attorney, you always want to have a backup in there. And the way that you appoint your attorneys can vary. So you might have a main attorney who would act initially with a substitute who would come on board should something happen to that first attorney. Or you might have 2 attorneys that you appoint, and either one of them could act depending on who was there or who was available. So we can really appoint the attorneys in whichever way you like. And the key thing is that you appoint someone that you trust. So usually that's a family member. So if you're married or in a relationship, you might appoint your husband, wife, or partner as your main attorney, and maybe one of your children as a substitute. Or if you're on your own, you might appoint your 2 grown-up children as your attorneys. It's usually family members that would be appointed. One thing I get asked about quite a lot is, what if my attorneys don't agree on something? What happens then? I think the key thing with that is to try and pick people who you think could work together and would be able to work together. And also they should be acting in your best interest. So they shouldn't be thinking about their own individual interests. They should be acting in your best interests. If you have 2 children who just don't get along, then I wouldn't appoint them as attorneys together. You could consider appointing one to act in one area of your life and one in another, perhaps. But what you don't want is a situation where they can't agree, because they might end up having to go before a sheriff to get a decision made. I'm also often asked if you can change your attorney later. So if you put your power of attorney in place, can you change your attorney later on? Yes, you can, as long as you have the capacity to do so. So you have to have the capacity to make that change. And also when you're putting the power of attorney in place, in the first instance, you have to have capacity. So we have a lot of clients that come to see us and they've maybe had a diagnosis of something like dementia or Alzheimer's, and their doctor has said to them, we really recommend power of attorney. Now, at that point, they may be well enough to still put this power of attorney in place, as long as they can understand the nature of the powers they're granting and the fact that they are giving power to someone else, and we're satisfied of that. There shouldn't be an issue. So the fact that someone has had a diagnosis of something doesn't necessarily mean that they can't put the power of attorney in place. That said, it's much better to do it early. So when you're healthy and well, think about a power of attorney and putting it in place. I mentioned that we have powers in the document that we give to the attorneys. So there are different types of powers. There are financial powers, and they cover things like dealing with your house, dealing with your bank accounts, dealing with pensions, savings, all of those kind of things. And we also have welfare powers, and that deals really with your health. And that's becoming more and more important nowadays because people are living longer, and it is sometimes more of a concern. So those types of powers would cover things like consenting to operations, even simple things like getting a prescription, getting your eyes tested, and also the care that you might need. Now, the financial powers that I mentioned, they can be used by your attorney while you still have capacity if you want your attorney to act at that point. So, for example, someone that maybe is still quite sharp mentally but physically can't get out could say to their attorney, could you start to help me with the bank? I just don't want to deal with them anymore. Or, you know, I'm not very good on the phone. I'm deaf. Can you start to act for me? And the attorney can do that. And then if you subsequently lose capacity, they can continue to act in that way. So those financial powers are actually called continuing powers in the deed for that reason. On the welfare side, it's a bit more black and white. So as long as you've got capacity, you should always make decisions about your health for as long as you possibly can. So that might be until you pass away. You might always have capacity. But if at any stage you lose capacity, your welfare attorney would start to make decisions about your health. And the decision about whether you've lost capacity is one that a doctor or consultant would make. So they would usually issue a letter or something to say that that person no longer has the capacity to deal with their own affairs. And that means the welfare attorney can start to make decisions in relation to health. I mentioned older people there who might have a diagnosis of dementia or something like that. We also put powers of attorney in place for younger adults. So, for example, someone who is approaching 16 and maybe needs assistance from their parents with certain things, maybe they've got some learning difficulties or something like that, but they still have capacity, they might want to put a power of attorney in place so that their mum or dad can continue to make decisions for them once they're over 16, because at 16, that's when they can start to make decisions for themselves. I've got a 15-year-old daughter, so that fills me with horror. But you might want to get that power of attorney in place at that stage. So it's not just for older clients. In terms of the process involved, you would normally come and see a solicitor for a chat, first of all, just about what power of attorney is, who you want to appoint as your attorney. And we also have to meet you to be satisfied that you have the capacity to grant the power of attorney. We would then go away and draft the document for you. You would have a good read through, you would check you're happy with it, and then we meet again. And the second meeting is for us to sign a certificate at the back of the document. And that's really for us to say that we're satisfied that you have the capacity to grant the power of attorney. So 2 meetings with a solicitor, and once it's signed, that's you done your part, really. Your attorneys, I'm often asked if they have to meet me, if I have to say the attorneys are okay. No, I don't have to meet them. I don't have to vet them in any way. It's up to you who you choose to act on your behalf. But the attorneys do have to sign a form, and the form is just to say that they're happy to act as your attorney. Now, they don't need a witness for that. It's a very simple form. We quite often email them out to attorneys, or they get sent out in the post. So it's a very simple process. And once that form is signed, we then submit the power of attorney to be registered with the Public Guardian's Office in Falkirk. That's a national body that deals with powers of attorney in Scotland. Unfortunately, at the moment, the registration process is taking quite a long time. I believe at the moment it's around 5 months to get a power of attorney registered, which is an awful long time if it's something you're wanting, to deal with things quite quickly. Now, that's the general waiting time. If there's an urgent situation, so for example, if the person has been taken into hospital, or if they're very vulnerable, or if the attorney needs urgent access to a bank account or something like that, we can accelerate that process. The decision on that rests with the Public Guardian, but usually if we accelerate, we might get the power of attorney back within about a week. So that is some good news. But generally speaking, most people are putting these powers of attorney in place for the future. It's almost like an insurance policy. You're taking it out just in case the worst happens. It's much easier to put the power of attorney in place when you're well and there's no urgency. It's much more difficult if someone has taken ill and they're in hospital and it's all a bit of a rush, and there's some urgency there. Were there any questions, Adele, that you had on powers of attorney that I've not covered in that brief summary there?
So, well, you did touch on how long does the process take. What's the cost involved in arranging a power of attorney?
So there's a registration fee that is paid to the Public Guardian's Office of £83 to register each power of attorney. Fees will vary from firm to firm slightly. It would be around about perhaps £300 plus VAT for a power of attorney for one person. That's the usual cost. I'm sometimes asked if legal aid is available for that type of work. That's not something that is usually available for that type of work. There's perhaps more scope for that in the guardianship side of things, and I'm sure Robin will speak about that later. But that's an idea of the fee, just to give you an idea of that.
Okay, thank you. Now, if I had my son as my power of attorney, for example, and I then passed away, what would my son have to do?
So the power of attorney falls away when someone dies. So if you've given your son powers over your affairs, when you pass away, the power of attorney can't be used after that stage, and your will would come into effect. So the power of attorney cannot be used once someone has passed away.
Does he have to notify anybody that that's happened?
Yeah, he would normally let the Public Guardian's Office know that you've passed away, just so they can update their records.
Okay, lovely, thank you. I suppose the last thing is, for argument's sake, if I decided not to get a power of attorney, but then was affected by an accident or a life-changing illness, what's the implications?
So if you don't have power of attorney in place and you've lost capacity, then the power of attorney route is really closed at that stage. You don't have capacity anymore. I would say, though, if someone comes in, it's always worth trying to go down that route. First of all, just to check if the capacity is there, if there's any doubt, because it's a much easier route, the power of attorney route. It gives you lots of control. You pick your attorneys, for example, you can say who you want to appoint, and you can see the deed that you're actually putting in place. But if you don't have capacity and you don't have a power of attorney, then guardianship, which Robin is going to speak about, is the road that you would have to go down. And that's a lot more involved. And you would have less control because you've lost capacity by that point.
Okay, thank you, Lorna.
No problem.
And I'll pass over to you, Robin, now to talk about guardianship.
Thank you, Adele, and thank you, Lorna. My name is Robin Beattie. I'm a partner at Thorntons Law, based in normally Forfar and Arbroath, although I do move around quite a lot. I specialise mainly in guardianship cases. Guardianship is the process that you may choose to follow if you have a loved one who does not have capacity to enter into a power of attorney. That might be somebody who has recently lost their capacity or somebody who has never had capacity. And by capacity, we mean the ability to make informed choices and judgments for themselves in their own best interests. If they don't have the capacity to enter into a power of attorney, and if they needed somebody to step in and make decisions for them, then you would probably wish to embark upon the guardianship process. By guardianship, we mean you obtain certain legal powers to make decisions for them in relation to their welfare and possibly also their financial affairs, depending on whether they have money that needs to be taken care of for them. The process involves applying to your local sheriff court, where a decision will be made by the judge or the sheriff who sits there. It's quite an involved process, and it can be quite stressful, and it can take quite a long time to finalise. That is why we always advise clients where their loved one does have capacity to try and encourage them to enter into a power of attorney before it might be too late to do so, because it's far preferable to have a power of attorney which is there and ready to be used as opposed to having to embark upon the lengthy guardianship process. For taking a guardianship case to the court, you're generally speaking advised to always have a solicitor to do it for you, because it's complicated and it's stressful and can be quite technically challenging to do it. So it's generally speaking advised to have a lawyer doing it for you. Once you've met with your solicitor and talked through your options with them, your solicitor then has to embark upon building the case up for you. This involves obtaining a variety of independent reports for the benefit of the sheriff, because the sheriff doesn't know your loved one, doesn't know you, and doesn't know the circumstances, and can't really make an assessment from the courtroom without the benefit of some independent input from those who can properly comment on matters. So the first thing we have to do is prove to the sheriff that your loved one lacks the appropriate capacity to make choices about the particular powers that you are seeking. Normally, we have to get two of them, one from your loved one's GP and another one from an independent psychiatrist, who sign off a template form to say what the diagnosis is and that they agree that they don't have capacity in relation to those particular powers. Along with those two reports, we need to lodge with the court a mental health officer's report, which is absolutely crucial. The mental health officer is an employee of your local authority who will come out and meet with the family, meet with you, meet with your loved one, and they will do a recommendation for the sheriff in terms of whether they think that your application is appropriate and suitable, or otherwise. They will also speak to any other family members to see if they agree that you are the best person to be doing this, and that what you're asking for is right. We would give that to the sheriff along with the two medical reports, and that would let the sheriff hopefully make an informed decision in your favour at that point in time. For the guardianship, you have to ask your solicitor for specific individual powers in the court papers. So you have to set out and justify every single power that you're asking for. So, for example, to make decisions about where your loved one should stay, to make decisions about your loved one's healthcare, to make decisions about care and support for your loved one. Those are the ones that we generally speaking ask for in every single case. Although there are more obscure ones that we have to add in some cases, such as monitoring your loved one's use of social media and the internet, making decisions regarding your loved one's diet, these kinds of things. And you have to tailor the powers to suit your individual circumstances, and your solicitor will be able to help you with all of that. Those powers all relate to personal welfare. You can also ask the sheriff for powers regarding your loved one's finances, although what I will say is the test for financial guardianship is quite a bit harder than the test for welfare guardianship, and we have to prove to the sheriff in a financial case that those powers are actually required. So, for example, if your loved one owns heritable property, or has substantial savings, or substantial income, or a substantial income, then in those situations, financial guardianship would be appropriate. Whereas in cases where maybe your loved one's on benefits, or maybe your loved one is a 16-year-old with no savings, then generally speaking, the court would expect you to take a different route for dealing with their finances, such as appointeeship with the Department of Work and Pensions. We're often asked how long does the guardianship process take? It's variable depending on where in the country you stay. That is because every local authority in Scotland has a different length of waiting list for a mental health officer. Some local authorities have a waiting list of over a year, and some have a waiting list of a month or two. So depending on where you live, the process may or may not be held up waiting for a mental health officer, which is unfortunate, but it's just the reality of the world that we live in, because it's a state-funded service, and some local authorities are a bit short-staffed just now. There's also a backlog of cases from COVID that maybe hasn't quite cleared in every jurisdiction just yet. Another question that I'm asked is about cost and about legal aid. So where your guardianship case includes a welfare element to it, which, to be honest, almost every single guardianship case does have a welfare element to it, civil legal aid is made available automatically to go to court. So That would include the costs of your solicitor, the costs of your 2 medical reports, and the cost of any court fees. And there is no means assessment for civil legal aid to go to court for that. That's because the Scottish Government decided that this should be made available to everybody where there was a welfare need, which is absolutely right and absolutely appropriate. There is sometimes a cost for all the work that your solicitor does before civil legal aid is approved, such as your first meeting, preparing your civil legal aid application, and presenting the statements to the legal aid board. You've got to give 2 statements, one from yourself and one from another person, a third party that knows you and your loved one. So we've got to prepare all of that and give it to the legal aid board for a decision to be made about funding. That portion of work that we do is means tested for legal aid. So depending on your loved one's circumstances financially, there might be a cost for the initial portion of work that we do, or legal aid might be available for that portion of work as well, depending on the means test. That is an absolute crash course in guardianships. I'm certain you will have some questions for me, and I look forward to hearing them.
Thanks, Robin. You touched on cost. I know it's impossible to say exactly how much, but could you give a ballpark figure of a guardianship?
Can do. It's variable depending how long it takes for us to actually get civil legal aid approved. It also depends on how many guardians there are, because it might be that there's more than one person that wants to be guardian. So in some cases we have 2, even 3 people that want to be joint guardians, and that involves doing 3 sets of legal aid forms. It's very hard to give a ballpark figure for that reason. Where there's only one guardian and it's reasonably straightforward and we get legal aid through and at the first bite of the cherry, it can be £400 plus VAT, £500 plus VAT, something along those lines. But we're pretty flexible about it, and we're happy to talk about funding options as well.
Okay, that's lovely. Thank you. So we have had some questions sent in. One was, would you recommend power of attorney or guardianship for someone very much affected by anxiety?
So for guardianship, there's a legal requirement to prove to the court that your loved one doesn't have the capacity to make decisions for themselves. If we can't do that, then it's back to the drawing board essentially when it comes to the guardianship side of things. So depending on how severe your loved one's anxiety is, it might be that they do have capacity, albeit they might be crippled by anxiety. In that situation, if the capacity was still there, despite the anxiety, I think power of attorney would probably be the answer to that, albeit that would involve your loved one instructing a solicitor to prepare a power of attorney for them. And in that situation, I think we would strongly recommend that a power of attorney be done sooner rather than later, just in case things get any worse. Because the guardianship process is more lengthy and stressful than the power of attorney process is, frankly.
Yeah, no, that's wonderful. Thank you. In what circumstances is it likely that the parent of a disabled child should become the child's guardian?
I get asked this question probably every day. Guardianship traditionally was always viewed as something that you do for an elderly loved one, such as a parent that perhaps has dementia or what have you. And traditionally, certainly, I think that probably was normally the case. Whereas I would say over the last sort of 10 years, we found that we get asked more and more for 16-year-olds who have just became adults legally, who have perhaps always carried an incapacity. The answer is that if your child lacks capacity to make decisions for themselves about their welfare, the parents should consider applying for guardianship before their 16th birthday. Because if you have a 16-year-old going out into the world that might be vulnerable and open to being exploited in a certain way, I think in every case of that nature, the parents should obtain legal guardianship for them so that they can protect them and keep them safe and make the correct decisions for them if they're not able to make them for themselves. So the answer is if the 16-year-old of the child doesn't have capacity, then I think in almost every case the parent should be considering guardianship.
Is there how soon before the child's 16th birthday could the process be started?
I would suggest around the child's 15th birthday. And that is because the process is so lengthy. By the time you've met your solicitor, sorted out legal aid, etc., and then once you're in the queue waiting for your mental health officer, so depending on where you are in the country, the queue might be over a year. So if you can get in the queue a year ahead of time, it seems to be the most sensible thing to do, is get it in it a year ahead. That way, when your loved one turns 16, then the overlap is as little as possible.
Certainly sounds like preparation's the key here for both of them. How long, again, talking about a child or 16-year-old, how long would guardianship last?
So traditionally, the court used to be allowed to give guardians indefinite orders. So an order that would last until either your loved one or the guardian themselves passed away. The European courts brought in regulations which suggested that was a violation of your loved one's human rights, that any order of such a powerful degree, which is essentially making full, unequivocal decisions for another human being, the European court decided that was a human rights violation, that actually it should be subject to regular reviews. The length of time is variable, and the order requires to be renewed before it expires. It's quite complicated, but I'll try to make it as simple as I can. Normally, when you're applying for a guardianship for the very first time, you would ask the sheriff to give you 3 years in the first place. And that would give the sheriff a chance to ask you to come back in 3 years' time to show the court that it's all gone well, that you've not abused your powers in any way or made bad decisions that have affected your loved one in any way. And you can come back to court after having been given a chance to prove yourself and say, I'd like to renew my guardianship, please. And maybe the second time around, could I have 5 years? And normally that is absolutely fine. If you succeed both times and go back 8 years after the original order was granted, you'll normally get a lot longer, such as 10 years the third time around. So it is subject to regular reviews, but we try to taper it up as we go.
It sounds almost like it's a protection for the loved person.
Absolutely.
I think that's, there is one thing. Does the law around power of attorney and guardianship change frequently? I'm just thinking about, well, we've got all this information. Is it likely to change in the next year?
I wouldn't have thought so. It's a process that I think is subject to some review. And I think a lot of guardians that go through it feel that they shouldn't be subject to such a rigorous process. That said, I am totally unaware of any proposals to revamp the system. I'm not aware of any pending changes to the legislation at all.
Thank you. I mean, we know things change. It's just really, I'm conscious of people watching this video and thinking, oh, right, okay, is this going to change next month? Is there a way that they could, well, I suppose if they're meeting with solicitors would keep them up to date with any changes, wouldn't they?
Yeah. I suppose if the law changes, I'll need to learn it from scratch.
Right, so lots of information. It sounds like the key point between the difference between power of attorney and guardianship is that the person that's being cared for has more choice and involvement in what happens. Is that right? Yeah.
Okay. Yes, I would say so. Yeah.
And it's a much less arduous exercise for everybody involved than guardianship. Okay.
Much better to get the power of attorney in place early while you can.
Right. Lovely. So could I just ask some key questions so that we finish on key points that people may think, right, oh, do I need to watch the whole video again? Could I just ask a couple of short ones? Yeah. So I suppose first one, power of attorney, there's not typically legal aid available.
Not usually.
No. And a typical cost is?
Around about £300 plus VAT, and a registration fee of £83.
Okay. And the process is, how would you describe the process?
2 meetings with a solicitor, very straightforward. We can do home visits, hospital visits if someone's not able to come into the office. It should be very straightforward. If you come back to us quite quickly about the draft, we can get it signed with you fairly quickly. We can accomplish the signing of it within a couple of weeks. It's the registration that takes a bit longer, as I mentioned earlier.
Yeah, okay. And the key thing is the person has to have capacity.
They have to have capacity to put the power of attorney in place, yes.
Yeah, okay. Is there anything I've missed, Lorna, that's really important?
I don't think so. You've been very thorough.
Thank you. Robin, it's your turn for the hotspot now. So, cost and legal aid, a quick summary.
So for guardianship, legal aid available in almost every single case, so long as there is a welfare component, and that will save you a lot of money going to court because that's the expensive part. Legal aid is not always available for the first bit of work that we have to do. That is means tested. So sometimes legal aid, depending on your loved one's means, sometimes there is an initial fee, which can be ballpark 400 or 500 quid plus VAT when there's only one guardian, more if there's 2 or 3.
Okay, and a quick summary of the process of guardianship.
Lengthy process that involves going to your local sheriff court. It involves obtaining at least 3 reports from independent people to show to the sheriff in support of your application. Your lawyer will go to court for you to ask the sheriff to grant it and get it all approved. Altogether, you're talking potentially a year, maybe more, depending on where you live in the country.
Okay. And the key point and the key difference between the power of attorney is the person doesn't have capacity for guardianship.
Yes. So guardianship is what you have to do when your loved one doesn't have capacity any longer, or perhaps has never had capacity. They can't sign a power of attorney without that capacity, and in those situations, that's when you need the guardianships.
Lovely. Robin, is there anything I've forgotten?
I don't think so.
Right, okay. Well, thank you both very much. I really appreciate the time that you've given to us and the carers. And the carers that have sent in their questions will be delighted to have them answered now. Again, thank you very much. Lovely spending time with you again.
Thanks for having us, Adele.
Thank you.
Very welcome.